Hi guys! Welcome to another episode of Attorney Javier Law Vlog. Today we continue with our discussion on the Intellectual Property Code. And specifically for today, we'll be continuing with our discussion on trademarks, but we will focus upon the violation of trademark rights, namely by infringement, unfair competition, as well as the remedies for those violations. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now, a like on this video or any of my other videos would also be greatly appreciated. So, in the last episode, we defined what a trademark and the other associated marks are. And today, we will discuss violations of trademark rights, again, specifically infringement and unfair competition. For our discussion, aside from relying on the Intellectual Property Code, otherwise known as Republic Act number 8293 as amended, we will also be relying on the different cases decided by the Supreme Court on this matter, including the case of UFC Philippines versus Barrio Fiesta, as well as the different associated cases. To review, a trademark is any distinctive word, name, symbol, emblem, sign, or device, or any combination thereof, which is adopted and used by a manufacturer or merchant on his goods to identify and distinguish his goods from those which are manufactured and sold or dealt by another person. A trademark, being a special property, is afforded protection by the law. But for one to enjoy legal protection, ownership of the trademark must properly be established. Now, the ownership of a trademark is acquired by its registration and its actual use by the manufacturer or distributor of the goods, which are made available to the purchasing public. Section 122 of the Intellectual Property Code provides that the rights in a mark shall be acquired by means of its valid registration with the Intellectual Property Office. A certificate of registration of a mark, once it is issued, constitutes prima facie evidence of the validity of the registration, of the registrant's ownership of the mark, and of the registrant's exclusive right to use that mark in connection with his goods and services and those that are related thereto, which are specified in the certificate. However, under the law, it is required that the applicant for the registration or the registrant himself must file a declaration of actual use within 3 years from the filing of the application for registration. Otherwise, the application shall be refused or the mark shall be removed from the register. In other words, the prima facie presumption brought about by the registration of the mark may be challenged and overcome in an appropriate action by proof of the nullity of the registration or of non-use of the mark, except when such non-use has been excused. Moreover, the presumption may likewise be controverted by a claim of ownership based on registration by a subsequent user. This is because a trademark is a creation of use and belongs to the one who first used it in trade or commerce. Again, what is important is actual use of the mark, okay? If someone has been using the mark before and then someone subsequently registers it but has no prior use, then it is the one who has actually been using the mark who is better entitled to to the ownership of the trademark. Okay, he just has to apply for registration now. The determination of priority of use of a mark is a question of fact. And adoption of the mark alone does not suffice. Hindi pwede yung you just say, hey, this mark is mine. Okay? You have to prove that you have used it in commerce. And of course, your claim of ownership over the mark, again, will be defeated by someone who has actually been using it for, especially for a long period of time. Okay? So one may make advertisements, he may issue circulars, distribute price lists on certain goods, but these alone will not support the claim of ownership of the mark until the goods bearing the mark are sold to the public in the market. Accordingly, receipts, sales invoices, and testimonies of witnesses as customers or orders of buyers, these will best prove actual use of a mark in trade and commerce during a certain period of time. As mentioned in the previous episode, the law protects the owner of the mark when it grants the registrant the exclusive right to prevent all third persons from using signs or containers for goods or services in the course of trade or business which are identical or similar to those owned by the trademark owner without the owner's consent, where such use by the third person would result in a likelihood of confusion. Again, if I am the owner of the mark, I can prevent other people from using that mark on similar or identical goods, okay? If I own the mark Attorney Javier Lovlog, I can prevent another person from using Attorney Javier Lovlog on his own YouTube channel or on any other TV station without my consent, okay? In this regard, the trademark owner can take action to protect his rights by preventing or punishing violations of his trademark rights. So now, we discuss how a registrant's trademark rights may be violated, namely by infringement or by unfair competition. So first, let's talk about infringement. And there is infringement if a registered mark is used in commerce by a person without the consent of the registered owner. Such use must cause confusion, okay? That's one of the most important elements, if not the most important element, okay? And under the law, specifically Section 155, infringement may be committed in two ways. First, it is committed by any person who shall use any reproduction, counterfeit, copy, or colorable imitation of a registered mark, the same container, or a dominant feature thereof in commerce. When we say in commerce, that means sale or offering for sale, distribution, advertising of the goods or services, or other preparatory steps necessary to carry out the sale of any goods or services, okay? So again, the first way of committing infringement is by any person who shall use any reproduction, counterfeit, copy, or colorable imitation of a registered mark, the same container, or a dominant feature in commerce in a way that is likely to cause confusion, mistake, or deception. That's very important. Take note of that. So in short, the first manner of committing infringement is the use in commerce of a copy or imitation of the mark that is likely to cause confusion. The second way of committing infringement is done by any person who shall reproduce, counterfeit, copy, or colorably imitate a registered mark or a dominant feature thereof, and apply such reproduction, counterfeit, or copy, or colorable imitation to labels, signs, prints, packages, wrappers, receptacles, advertisements to be used in commerce, which is likely to cause confusion, mistake, or deception. Okay, again, under the first way, it's the use in commerce of a copy or imitation of the mark that is likely to cause confusion. In the second, it's to actually reproduce or copy the mark, apply the mark to labels, to use it in commerce, which will cause confusion. Okay? Simply put, infringement is the use by others without the consent of the registrant of a reproduction or colorable imitation of the owner's trademark with the purpose of causing to mislead or actually misleading the public that such goods or services originated from the trademark owner where such is not the fact. Take note that only marks that are registered are protected against infringement or unauthorized use by others. Okay, so the marks have to be registered in order for you to be for the trademark holder to be protected against infringement. Okay, take note also that infringement takes place at the moment any of the acts that I mentioned are committed, regardless of whether or not there is actual sale of goods or services covering the infringing material. Okay, so the actual sale is not necessary, okay? As long as the person uses the mark in commerce or reproduces, then applies that mark to labels, etc., then infringement is committed. So, in order to bring a civil action for infringement, it is not required that there be an actual sale of the goods or services using the infringing material. Infringement takes place upon the mere use or reproduction of the registered mark. So how do we know that there has been infringement? To establish trademark infringement, the following elements must be shown. First, the validity of the trademark. Okay, the trademark must be shown to be valid. Second, ownership of the mark. You must show that that person is actually the owner of that trademark. Third, the use of the mark or its colorable imitation by the alleged infringer results in the likelihood of confusion, and that is the gravamen of the offense. In other words, the essential element of infringement is the third element, that the use of the mark or its colorable imitation by the alleged infringer results in the likelihood of confusion. And when we say colorable imitation, it is such a close or ingenious imitation as to be calculated to deceive ordinary purchasers, or such resemblance of the infringing mark to the original as to deceive an ordinary purchaser giving such attention as a purchaser usually gives, and to cause him to purchase the one supposing it to be the other. Okay? So when you pick up an item thinking it to be whatever else you wanted to buy supposedly, then there is confusion. You have mistaken this item for that which you actually wanted to buy. On the question of confusion of marks and trade names, jurisprudence has noted two types of confusion. Namely, first, we have confusion of goods or product confusion, where the ordinarily prudent purchaser would be induced to purchase one product in the belief that he was purchasing the other. Okay, so that's what I was talking about earlier. And the second kind of confusion is confusion of business. Okay, or source or origin confusion. Here, in confusion of business, where although the goods of the parties are different, the product whose mark is being applied for registration by the third person is such as might reasonably be assumed to originate from the registrant of an earlier product, and the public would then be deceived either into that belief or into the belief that there is some connection between the two parties, though inexistent. Such as in the example I gave in the last episode for the trademark Mikey for shoes. If a third person would use the trademark Mikey on socks, it might confuse the public into believing that Mikey had branched out into producing socks to accompany the shoes, where the truth is that it's actually a different manufacturer. Okay? So that is what the law seeks to prevent. Now, in determining similarity and likelihood of confusion and ultimately the existence of infringement, jurisprudence has developed two tests. We have the dominancy test and the holistic test. The test of dominancy focuses not only on the similarities in size, form, or color, but on the main or essential features of each mark taken together. The test requires that if the competing trademark contains the main or essential features of another and confusion or deception is likely to result, then there is infringement. Now, duplication or exact imitation is not necessary. Okay, such as in the case of the symbol of guess, where instead of a question mark, it's an exclamation point. Okay, so in that case, there's no exact imitation. Okay, so duplication or exact imitation is not necessary, nor is it necessary that the infringing material or label suggest an effort to imitate. Focus is given to the similarity of the prevalent features of the competing trademarks that might cause confusion, such as the oral, meaning auditory, the oral and visual impressions created by the marks upon the buyers of the goods. And this test gives little weight to factors like prices, quality, sales outlets, and market segments. Now, for the holistic test considers the mark as a whole. Okay, kaya nga holistic. And it does not dissect the mark into parts. If the buyer is deceived, it is attributable to the marks as a totality, not usually to any part of it. You do not simply take the words and compare the spelling and pronunciation, but you take the marks in their entirety as they appear. And then you consider them in relation to the goods to which they are attached, focusing not only on the predominant words, but also the other features. You consider the entirety of the marks as applied to the products, including the labels and packaging, in determining confusing similarity. Where the holistic test relies on a visual comparison, you compare them by looking at them, between two trademarks, the dominancy test relies not only on the visual, but also the oral and connotative comparisons, as well as the overall impressions. Take note of the 2001 case of Society Nestlé, Nestlé versus Court of Appeals, where the Supreme Court explicitly rejected the holistic test by saying that the totality or holistic test is contrary to the elementary postulate of the law on trademarks and unfair competition, that confusing similarity is to be determined on the basis of visual, oral, connotative comparisons, and overall impressions engendered by the marks in controversy as they are encountered in the realities of the marketplace. The fact that we now adhere to the test of dominancy is that it is now explicitly incorporated into law, specifically Section 155.1 of the Intellectual Property Code, which defines infringement as the colorable imitation of a registered mark or a dominant feature thereof. Okay, so we use the dominancy test. In this regard, here are some examples of early cases, like in Marvex versus Petra, where it was held that Lion Pass cannot be registered because it is confusingly similar to Salon Pass because of their similar pronouncement. In American versus Director, the Supreme Court denied the registration of Dynaflex for the confusing similarity in pronunciation, appearance, and similar goods packed in boxes of the same material, color, shape, and size with those of Duraflex. Okay, so aside from Dynaflex sounding similar to Duraflex, their goods were not only similar, their packaging was also similar. The dominant elements of the designs of Dynaflex were similar with Duraflex. However, in other cases, the Supreme Court also allowed registration, such as in the case of Alacta, when it was compared with Alaska, or the registration of Atusin despite the earlier registration of Pertusin, because in both cases, the trademarks in their entirety as they appeared in their respective labels, they showed glaring and striking differences or dissimilarities, such as in the size of the containers, the colors of the labels, so that the label of one could not have been mistaken for the other. So what we get from these cases is that really you determine if there is infringement or unfair competition, for that matter, on a case-to-case basis. Okay, and that said, we still rely mainly on the test of dominancy. Take note further that regard must also be given to the class of persons who purchase the product. In this regard, we have the case of Lim Hoa versus Director, where it was said that the danger of confusion in trademarks and brands which are similar may not be so great in the case of commodities or articles of relatively great value, meaning expensive, no? Like radio or television sets, air conditioning units, machinery, etc. Because the prospective buyer, who is usually the head of the family, before he makes the purchase, he is presumed to have read pamphlets or any literature available which describes the article he is planning to buy. And perhaps he even makes comparisons with similar articles in the market. In other words, he is not likely to be deceived by a similarity in the trademarks because he makes a more or less thorough study of the same, and he may even consult his friends about the relative merit and performance of the article or machinery as compared to others that are for sale. The difference lies in case of, for example, food seasoning, which was the topic of the subject of this case. Food seasoning is a kitchen article of everyday consumption, like yung mga Knorr, no? Or Maggi Sabor. So, the circumstances for the purchase of these products are far different. These products are generally purchased by cooks, household help, sometimes even illiterate persons according to the Supreme Court, who are guided by pictorial representations and the sound of the word descriptive of said representation. In this case, the competing marks were of two roosters appearing in the trademark of the applicant and the hen appearing on the trademark of the oppositor. Although that the birds were of different sexes, they belong to the same family of the chicken known as manok, okay, in the principal dialects of the Philippines. And when a cook or a household help or even a housewife buys a food seasoning product for the kitchen, the brand of manok or marka manok would most likely be uppermost in her mind and would influence her in selecting the product, regardless of whether the brand pictures a hen or a rooster or two roosters. To her, they are all manok, and therein lies the confusion, even deception. So that's what it said in Limhoa. Okay, there is a difference between the discerning purchaser when it comes to buying expensive items like TVs, refrigerators, etc., as compared to everyday household items like soy sauce, seasoning, etc., which is the same line of argument in the case of Emerald versus Court of Appeals, which involved the mark stylistic Mr. Lee for jeans and against the brand simply named Lee, also for jeans, okay? The mark stylistic Mr. Lee for jeans was held not to be confusingly similar to the Lee brand of jeans because according to the Supreme Court, maong pants or jeans are not cheap. So the casual buyer is bound to be more cautious and discriminating and would prefer to mull over his purchase. Should I buy this or not? Making confusion and deception less likely. Moreover, the average Filipino consumer generally buys his jeans by brand. He does not ask the sales clerk for generic jeans, but for like, let's say, Miss, can I have a Levi's, Guess, Wrangler, or even Armani? He is therefore more or less knowledgeable and familiar with his preference and will not be easily distracted. As such, he is not a completely unwary customer, but is the ordinarily intelligent buyer who considers the type of product involved. Okay? The Supreme Court further said that the test of fraudulent simulation is to be found in the likelihood of the deception of some persons who are somehow acquainted with the established design, who want to buy that particular commodity bearing that established design. The test is not found in the actual or possible deception of the person who knows nothing about the design which has been counterfeited. The test is whether the goods appear to be likely to mislead the ordinarily intelligent buyer who has a need to be supplied and is familiar with the article he seeks to purchase. Indeed, a personal name or a surname may not be monopolized as a trademark, and there can be no monopoly on Lee as a surname. Worthy of note is the 2016 case of UFC versus Barrio Fiesta, which both involved the mark Papa. Okay? In case of UFC, it's Papa Ketchup. And Barrio Fiesta, Papa Lechon Sauce. Okay? Here in this case, the Supreme Court recounted several cases to support its position that it should be the dominancy test which is favored. Okay, it first cited the case of Skechers USA versus Interpacific, where the dominancy test was used to find that the use of the stylized letter S of Interpacific on its rubber shoes infringes on the mark already registered by Skechers because the stylized letter S is the dominant feature of the trademark. Based on the font and the size of the lettering, the stylized S used by Interpacific is the same as the stylized S used by Skechers, thereby likely to cause confusion as purchasers will tend to associate Interpacific's use of that letter S as having been authorized by Skechers, or that Interpacific's product is connected with Skechers' business. Further, while there may have been dissimilarities between appearances of the shoes, such dissimilarities do not outweigh the stark and blatant similarities in their general features. The Supreme Court also cited the McDonald's versus LC Big Mac burger. Those of you who are a bit older may still remember the Big Mac burger, no? Which is it's a stall like Burger Machine or Minute Burger, no? In this case of McDonald's versus LC Big Mac Burger, the Supreme Court relied on the dominancy test, where greater weight is given to the similarity of the appearance of the product arising from the adoption of the dominant features of the registered mark, disregarding their minor differences. In finding that the use of the mark Big Mac by LC Big Mac to likely cause confusion with McDonald's mark the Big Mac, the Supreme Court looked at both the spelling and the pronunciation of the marks, thereby not looking only at the visual but also the oral, no, the what it sounds like aspects of the mark, okay? Especially since they are both used for hamburgers. Big Mac for McDo has a C. Big Mac for LC Big Mac has a K. Okay, but both sound the same. Okay? Ultimately, in the UFC versus Barrio Fiesta case, the Supreme Court relied on the dominancy test to state that Barrio Fiesta cannot register the mark of Papa for its lechon sauce because it causes confusion with the mark of UFC of Papa for its ketchup. Barrio Fiesta's mark is related to a product, specifically lechon sauce, which is an everyday all-purpose condiment and sauce that is not subjected to great scrutiny and care by the casual purchaser, who knows from regular visits to the grocery store under which aisle to find it, okay, in which bottle it is contained, and approximately how much it costs, okay? Like when I go to the grocery, I already know which stalls I will go to, okay, and relatively I know how much I'm going to spend. Since UFC's product, ketchup, is also a household product which is found in the same grocery aisle, also in a similar packaging, then the public could think that UFC had expanded its product mix to include lechon sauce, and that Papa Boy lechon sauce is now part of the Papa family of sauces, which is not unlikely considering the nature of business that UFC is in. Thus, if registration is allowed, confusion of business may set in, and petitioners' hard-earned goodwill may be associated to the newer product introduced by Barrio Fiesta, all because of the use of the dominant feature of UFC's mark UFC's mark, which is the word Papa, okay? The words Barrio Fiesta are not included in the mark, and although they are printed on the label of Barrio Fiesta's lechon sauce packaging, they still do not remove the impression that Papa is a product owned by the manufacturer of Papa Ketchup. Okay? It is possible that UFC could expand its business to include lechon sauce. And that would be well within UFC's rights. But the existence of a Papa Boy Lechon sauce would already eliminate this possibility and deprive UFC of its rights as an owner of a valid mark included in the Intellectual Property Code. Okay? So now, let's say that infringement has been committed. What are the remedies? The trademark owner may file an action for damages. He may ask that the infringing goods be impounded and or destroyed. He may also pray for double damages under Section 156.3, where actual intent to mislead the public or to defraud the complainant is shown. He may also ask for an injunction to stop the unauthorized use of his trademark. He may also file a criminal case and other administrative sanctions. However, take note that in order for the owner of the trademark to be entitled to recover damages, he must show that the infringing acts were committed with knowledge that such imitation is likely to cause confusion, mistake, or deception. Such knowledge is presumed if the registrant gives notice that his mark is registered by displaying with the mark the words registered mark or the letter R within a circle. I'm sure you have seen this. Or if the defendant had actual notice of the registration. Take note now that the law imposes certain limitations on the remedies against infringement. First being, the owner of the mark cannot sue a third person for infringement if he was using the mark for his business or enterprise in good faith and before the filing or priority date. Okay? Second, if the acts of the infringer relate to printing, publishing, or distributing the infringing mark or advertisements, whether print or electronic, and the infringer is found to be an innocent infringer, the owner of the mark can only bring an injunction against future printing or releases. Now, the law also protects the goodwill created by the use of the mark. According to Section 168, a person who has identified in the mind of the public the goods he manufactures or deals in, his business or services from those of others, whether or not a registered mark is employed, he has a property right in the goodwill of said goods. Okay, to make it short, if a person has goods or services that he has managed to identify in the mind of the public, okay, then he has a property right in the goodwill of those goods, businesses, or services. Okay? And if he has goodwill, that will be protected in the same manner as other property rights. To review the definition of goodwill, please just watch my previous episode. Okay? Now we can move on to unfair competition. Unfair competition is the use by a person of deception or any other means contrary to good faith, by which he passes off the goods manufactured by him or in which he deals or his business or services for those of another person who has established goodwill in the goods that he manufactures or deals in. Okay? The law gives us some examples of unfair competition. First, any person who is selling his goods and gives them the general appearance of goods of another manufacturer or dealer. Okay? Take note of that keyword, no? The keywords, general appearance, gives them the general appearance of goods of another manufacturer or dealer, either as to the goods themselves or in the wrapping and packages in which they are contained, or the devices, no, or the words thereon, or in any other feature of their appearance which would be likely to influence purchasers to believe that the goods offered belong to someone else. Okay? Also, he may otherwise clothe the goods with such appearance as shall deceive the public and defraud another of his legitimate trade, or any subsequent vendor of such goods, or any agent of any vendor engaged in selling such goods with a like purpose. That's very long, no? That's the wording of the law. Simply put, if you make if you produce goods and then you give it the general appearance that it belongs to someone else, like through the wrapper or through the goods itself, the container, and you pass it off as coming from the original manufacturer, then this is one form of unfair competition. Again, the passing off of your goods as belonging to another. You are riding on that other person's already established reputation and goodwill. Another example of unfair competition under the law is any person who by any artifice or device or who employs any other means calculated to induce the false belief that such person is offering the services of another who has identified such services in the mind of the public. The same as earlier, no? But instead of goods, this time services. I am offering services, trying to make it appear that my services are connected or come from someone else who already has an established reputation or goodwill. And one more example under the law, any person who shall make any false statement in the course of trade or who shall commit any other act contrary to good faith of a nature calculated to discredit the goods, business, or services of another. Okay? That's paninira, to make it short. So in general, the elements of unfair competition are, first, confusing similarity in the general appearance of goods. Okay, you can't tell if it's fake or not. Okay, that's how simple it is. Second, intent to deceive the public and to defraud a competitor. Now, the confusing similarity may or may not result from the similarity in the marks, but may result from other external factors like the packaging or the presentation of the goods. The intent to deceive and defraud may be inferred from the similarity of the appearance of the goods as offered for sale in the public. Okay, they are made to appear as if they came from someone else. The test of unfair competition is whether certain goods have been intentionally clothed with an appearance which is likely to deceive the ordinary purchaser exercising ordinary care. And as such, inspection should be taken from the viewpoint of prospective buyers. Stated differently, the true test of unfair competition is whether the acts of the defendant have the intent of deceiving or are calculated to deceive the ordinary buyer making his purchases under the ordinary conditions of the particular trade to which the controversy relates. One of the essential requisites in an action to restrain unfair competition is proof of fraud. The intent to deceive, actual or probable, must be shown before the right to recover can exist. In the 2014 case of Ko versus Young, Ko was found guilty of unfair competition, which was defined as the passing off or palming off or attempting to pass off on the public of the goods or business of one person as the goods or business of another, with the end and probable effect of deceiving the public. This takes place where the defendant gives his goods the general appearance of the goods of his competitor with the intention of deceiving the public that the goods are those of his competitor, no? So here, in this case, the act of Ko constituting unfair competition was his conspiring in the sale and distribution of counterfeit greenstone products to the public. Okay, these counterfeit products were even packaged in bottles which were identical to that of the original, thereby giving rise to the presumption of fraudulent intent. He was selling counterfeit products to the public, making it appear that his products belonged to or originated from greenstone. So that is unfair competition. And as for the remedies in unfair competition, the remedies are the same as those I mentioned in infringement. Take note that infringement is different from unfair competition. As for the nature of the offense, in infringement, it is the unauthorized use of the mark. Okay, the use of the mark without the owner's consent. Whereas in unfair competition, the nature of the offense is the passing off of one's goods as those of another's. No, you're making it appear that your goods also came from another. As to existence of fraudulent intent, that is not necessary in infringement, but fraudulent intent must be established in unfair competition. In infringement, prior registration of the mark is necessary, but it's not necessary in the case of unfair competition, as held in the case of Del Monte versus Court of Appeals. As for infringement, this refers to goods that are in a similar class, similar or identical. But in unfair competition, the marks may refer to different or unrelated goods. And finally, we have Section 169 on false designation of origin, false description, or representation, okay? Which allows the owner of a mark to file a civil action for damages and injunction against any person who uses a container in commerce who uses a container in commerce of any word, symbol, device, combination thereof, or false designation of origin. Okay, his statement of where it came from is false. No, like let's say it came from Russia, but he says it comes from the Philippines, like that. False or misleading description of fact. Okay, the description is false. Or false or misleading representation of fact on his goods or services, which first is likely to cause confusion, mistake, or to deceive as to the affiliation, connection, or association of such person with another person, or as to the origin, sponsorship, or approval of his or her goods, services, or commercial activities by another person, or in commercial advertising or promotion, misrepresents the nature, characteristics, qualities, or geographic origin of his or her or another person's goods, services, or commercial activities. Simply put, the law seeks to prevent the use of false descriptions, false designation of origins, which is likely to confuse the public, okay? Ang iniiwasan lang dito ay panloloko or fraud. Okay? So that's it for my discussion on trademark infringement and unfair competition, as well as the remedies. I hope you may have picked up a thing or two, and please wait for my episode on copyrights. Okay? I hope to see you soon, guys. Bye!